Wow, beautiful piece. We hope you enjoy it. On Wednesday again, we'll bring you fresh edition on that piece. It is Legend of Quran, and we hope that you'd like to see it to the very end. Okay, it's about time that we discuss something very important that affects every one of us, that affects Nigeria as a nation. And what is that thing? Of course, everything Nigeria talks about today is, moving or aiming towards the 2019 general election. It is, the preparation is on the climax, and on social media, on traditional media such as TVs and radios, you can discussing 2019 general elections, and preparation for it will not be out of place. Yes, that is something that is now making waves on social media and everywhere. It is a subject of discussion here and there, and it's nothing but a decline, or should I say the refusal of the President Muhammadu Buhari on the electoral bill presented by the Senate. This, no doubt, has generated quite a lot of comments from different quarters, and the letters he wrote answering or responding to such comments from different people, as Buhari himself writes, "Why I refuse to sign electoral bill." I just want to quickly run through it and read few from it, and then we'll come back to receive our guest in the studio. Now, President Buhari's letter to Senate reads, "Pursuant to Section 58, subsection 4 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, I hereby convey to Senate my decision to decline presidential assent to the Electoral Amendment Bill 2018, recently passed by the National Assembly." Now, the point here is, Buhari says, all right, "I'm declining assent to the bill principally because I am concerned that passing a new electoral bill this far into the electoral process for the 2019 general elections, which commenced under the 2019 Electoral Act, could create some uncertainty about the application legislation to govern the process." Now, before we continue to read on and on, we want response from the legal angle, and this morning, luckily, we have a legal doyen, I would say, on my right side, a constitutional law expert, and of course senior lecturer, Department of Public Law, University of Ilorin, Dr. Abdulfatai Sambo. It's a blessing having you on set this morning.
It's really a good pleasure to be here.
Thank you. Pleasure indeed.
Yeah, thank you.
Yeah, thank you for coming. And of course, to do justice, of course, to balance the stage or the set, as it were, we have a public affairs commentator or social commentator, so to say, comrade. I hope I'm right using the word comrade. Okay. Okay, Isa Motalib Ayobami. It's a pleasure having you here.
Thank you very much. It's nice being here.
You're welcome.
Thank you, sir.
Now, let's begin with before we begin to look at what Buhari writes, or the comments from different quarters, from Nigerians, what do we call them, the politicians, the supporters, and of course, ordinary Nigerians generally, because it is what we get to hear from these people, the game players, that affect the rate at which, or should I say, the thinking of a common man on the streets of the Nigerian streets. Now, we want to look at this, put it on the table, and explain or look at the justification behind either accentuating it or declining such bill. Now, before we progress to discuss this, what is electoral bill? We need to understand what that is, why we need that, and of course this time that we are having it. What is electoral bill?
Oh, thank you very much. The electoral bill is just the law that governs elections, simply put, in Nigeria. And of course, there cannot be any system of constitutional democracy without a institution where we have electoral bill into law. For instance, now in 2003, it was even amended in 2023. We have the 2006 Electoral Act. We have the one of 2010. In fact, in 2010, that 2010 Act actually repealed the 2006 Electoral Act. Now, what you actually want to do is to amend the 2010 Electoral Act. It was even amended in 2015, during the period of Goodluck Jonathan. But what they are talking about now is just to give us a particular law. Of course, laws require amendments. You can't have a law that will go on.
I was just about to ask you, is it a periodic thing? You know, when we talk about electoral bill now, is it subject to any election, maybe any...
it's not actually. It depends. You see, what Nigerians should actually understand is ours is separation of powers.
Ours is what?
Separation of powers.
How do you mean by that?
In separation of powers, powers are consciously shared among the three arms of government, namely the executive, the judiciary, and the legislature. If you look at Section 4 of the Constitution, that confers legislative powers in the legislature. Section 5 confers executive powers in the executive, while Section 6 confers judicial powers in the judiciary. And separation of powers admits checks and balances, because we can have a situation of pure separation. What we operate in Nigeria is partial separation. Partial separation means that we now allow a situation where there will be checks and balances. And one of the ways in which the executive will check the excesses of the legislature is through giving assent to this particular bill.
Does that explain why the executive arm of government will have to, before taking any decision, will have to go through the legislators for accentuation or for acceptance?
Yeah, because you see, this particular electoral bill, you must understand that the bill actually emanated from the National Assembly. It wasn't an executive bill. The bill emanated from the National Assembly. Now,
I need to get something. When we talk about this electoral bill, where exactly or precisely is it expected to emanate? Is it, since it's a law for the nation itself, it is in the interest of the nation, in Nigeria as a state. Now, where is it expected to come from? Is it going to be a unilateral decision, or maybe from one particular arm of government?
There is what we call the executive bill, and we have what we call the House or the Senate bill. So it could come from either the executive or the legislature.
Are you sure about that?
I'm very sure. Now, looking at Section 58 of the Constitution. Now, Section 58 talks about a situation where, to the fact that no law will be deemed to be valid in Nigeria, duly passed by the National Assembly, except that bill is given assent to by the President under Section 58 sub 1. Okay. Now, if a bill is presented by, just like what we have now, the bill emanated from the House of Reps, went to the Senate, then back to the President for assent. Now, the law is that the President has 30 days to either withhold or give his assent, in line with Section 58 sub 4 of the Constitution. Now, it is within the prerogative of the President to either give assent or refuse assent.
Within 30 days?
Within 30 days. So if he feels that, yes, this bill is in national interest, he may decide to give assent, otherwise he may withhold it. That Section 58, looking at it from subsection 1 to 5, does not actually mandate the President to give reasons. So the fact that the President has even given reason why he actually decided to decline assent is a kind of surplusage. Of course, it's
a kind of what?
Surplusage.
How do you mean?
The law, which means that it's not necessary. But he decided to give reasons so that the National Assembly will see.
No, let me get it. I want to get this in clear terms now. You said providing reasons for not, assenting it is not necessary.
It's not necessary.
So he has that power to decide on whether he's going to, let's say, accept it or decline.
Exactly.
Without having to give any.
Without having to give any reason.
How do we justify that?
Yes, because looking at the provision of Section 58, Section 58 is very clear, and it has 5 subsections. And those subsections, there is nowhere in those subsections where the President is required to give reasons for not giving assent. What the law says is that the President can decide to either give assent or withhold assent. So if he decides to give reasons, fine. If he doesn't want to give reasons, nobody can compel the President to give reasons. Because what we have to understand is that when the law says an executive power is vested in somebody.
Okay.
If you look at section 5, it says the executive powers of the federation shall be vested in the president. The implication of that shall is that it is mandatory. You can't confer such powers on any other arm of government, except the president decides to delegate such powers.
Okay.
So, if there's something is vested, the constitutional implication of that is that he is the original owner of that power.
Okay.
And the power to give assent to a bill is his original power. Well, he's expected to act in national interest in giving or withholding assent to a particular bill.
In giving or
withholding assent.
Okay, okay.
But if he doesn't want to, it's up to him. It's up to him.
Now, away from him maybe withholding or giving it or maybe accepting it as it were now. Now, the review of that electoral bill as it is now, when exactly, I want you to talk from the legal angle, from the legal perspective actually, are we or is it expected to emanate from whichever arm of the government, either from executive or from legislator? Is it before the electoral process, begins, or after or during? You understand what I mean? Okay. Now, if such law is going to be reviewed, or maybe is going to be amended, or whatever that the bill is going to attract, should it be, let's say, well ahead of time, like 2-3 months or a year before? When should we expect such law to come out? Or is it lawful that we have it anytime, either before, during, or even after?
Well, I think we can have it anytime, but the problem is there is Article 2 of ECOWAS Protocol on Democracy and Good Governance.
ECOWAS Protocol?
On Democracy and Good Governance, which Nigeria is a signatory to. That Article 2 says that no nation...
And that has a bound with our national laws?
Yes, because if you look at Section 12 of the
Constitution here...
If you look at Section 12 of our Constitution, that section says no treaty shall become law until it is enacted into law by the National Assembly and assented to by the President. However, if you look at Vienna Convention on Law of Treaties, 1969, Article 26 of that convention says that pacta sunt servanda, which means that parties are bound by their treaties.
Pacta
sunt servanda.
Sunt servanda.
Which means that parties are bound by their treaties. Looking at Article 27 of that particular treaty, Vienna Convention on Law of Treaties, which Nigeria is a signatory to, it says that no nation shall hide under its own local laws or municipal laws or national laws to violate any international obligation. What is the international obligation in this particular circumstance? International obligation is that we must not have any electoral amendment, substantial amendment to any electoral law, 6 months before election. That's what that protocol, Article 2 of that protocol provides for. Once it is after, 6 months before that election, that process is deemed not to be credible. It will be seen as, if you look at old Section 19 of D of the Constitution, one of the foreign policies of Nigeria is respect for international law, respect for international treaty, respect for international convention.
Okay, well, Barrister, I hope we'll have more light on that area which you are attending us. Now, I'll come back to you, and I just quickly want to continue with what the President writes. Now, you've said that the President, let me take my comrade, Asa Mutalib Ayobami, from there. Now, he said that the law gives him that power to withhold or give to any bill, for accentuation. Now, the President deemed it fit to explain why he refused to sign or to assent such electoral bill in this time. What is your take on that?
Okay. The first thing is we have to look at the reasons the President gave. Are they valid or not? And I believe the principal reason he gave has been explained. When you read it out, he also gave some some insights on it.
Okay, let me quickly go. I just want to run it, so I want you to comment. He said, this leads me to believe that it is in the best interest of the country and our democracy for the National Assembly to specifically state in the bill that the Electoral Act will come into effect and be applicable to elections commencing after the 2019 general elections. Now, in this situation now, would you say that the president has taken a decision truly in the best interest of the nation, or is there an ulterior, motives to that refusal?
Okay.
As put in some quarters, the comments we got from other people.
Every act is an act of politics. It's something you cannot dispute. But the fact is, what are the reasons that are being given, and are they valid, as I've said earlier on?
Okay.
The time frame is something that you have to put into consideration.
Okay.
The electoral process has begun. Part of the reason that he gave us, there was misconception about a 21 days and a 90 days from the former bill and the present bill.
Okay.
That is in respect to what? To INEC, because the electoral bill is just guiding INEC on how to conduct its elections.
Okay.
So now we are just less than 2 months into the election, and you are introducing what? New laws. Because there are some technicalities that you have to put into consideration. Because the president, before he can attend to a bill, he also has his team that he has to bring about. Maybe the legal advisor. We have a vice president who also happens to be a professor of law.
Okay.
So what if this electoral bill is invalidating all that INEC has done? Then which means after the election we have lingering court cases. Because a party, let's say a party XYZ that lost the election, the party knows that it's duly lost the election. But if the party has technical grounds to prove in the court of law that there should be another fresh election.
Okay.
And the law, as we all know, it has loopholes. As he rightly said, the substitution he quoted that it does not even give the president the right to even give reasons. The president can either give reasons or not.
Okay. Okay.
So these are technicalities that people will try to how would I put it? People will try to dig into it.
Okay. And
at the end of the day, after the elections, then they are telling us to conduct a fresh election. I'm just trying to picture a scenario.
Now, given the standard of the country, Nigeria as a nation, our standard here, I wouldn't want to use the word maturity here, but we've not really attained that stage that we begin to look at it from maybe this angle. Okay, well, that's the way it goes. There will be some degree of litigations here and there, challenging this. Maybe you should now break this down. Maybe he has explained from the legal angle here what the electoral bill is all about. Now, what are the things captioned in this amendment or review from the Senate in that electoral bill as proposed? What are the things that we expected? Because from what I gathered, they were talking about some maybe
electronic transmission.
What?
Electronic transmission.
Electronic transmission, maybe captioning, or maybe use of CCTV and some other things. So what are the things that the Senate proposed in that bill?
Okay. Actually, the bill was also amended in 2015.
Okay.
That was what brought about the issue about card reader.
Okay.
Even though it was just like it was just a shadow amendment, it was not a thorough amendment.
Okay.
Because then the INEC chairman, Professor Atayu Jega, it was when I brought the issue of card reader.
Okay.
Also very close to the election, I would say. I'm not sure of the time, but it was very close to the election.
Okay.
So the Senate just did their normal rush and it was approved.
Okay.
And it was captured in the 2015 Electoral Act.
Okay. Okay.
So in 2016, they began the review.
Okay.
That is 2016, and we are now in 2018.
Okay.
That's about 2 years, either a little bit less or a little bit more. 2 years. It was the electoral act the review began in 2016.
Okay.
And the president declined assent 4 times.
Really?
This was the 4th time he declined assent.
Now, from what he said now, you want to say something to it, because I never even realized this, that maybe the bill has been passed to the president before, well ahead of time, even before now, 4 times. What's your opinion on this?
Well, I think the law does not actually stipulate the number of times that the president is required to either give assent or refuse assent.
No, given the reasons provided by the president.
Yes, what the law says is that the president has 30 days under Section 58 sub 4 to actually withhold his assent or give his assent. Now, if you look at, since the time the electoral bill has been coming before the president, his president has never spent beyond the required 30 days. Sometimes, in fact, that bill spent about 9 months in one of the houses of the National Assembly. So that means when the president spends 30 days, the thing goes back to the National Assembly, he spends another 3 months, 4 months, 5 months before it comes back to the president again. He spends another 30 days. He declines assent. And if you look at the reasons, even the third amended version does not have the provision for card reader. But if you look at this particular one, I think it's just too close to election. And if it's too close to election, you can't amend a law substantially without the concurrence of the political parties. You must have the majority of political parties must sit together and agree that there should be a substantial amendment to the law. Otherwise, the international committee will not see that particular effort as credible.
Comrade Issa, I want you to respond to 2 questions here now. Now, people say, they insinuate, so to say, that the president's refusal is in the interest of his party, or maybe because he's afraid that he's afraid of losing 2019 election. How true would that be?
As I said earlier, every action is an act of politics. But the fact remains, let me talk about the electronic transmission clause. It says that all results shall be transmitted electronically. What does that mean? Through the use of what? Internet. Now the question we should ask ourselves is, how many suburbs, localities and villages have internet connection? So how do you expect results to be transmitted electronically, let's say from village A or from village K, when they can't even make phone calls?
Even the networks available as we speak. Even in some urban areas, there
are some areas that their network is very, very bad. So how can such become law? What provision? Okay, let's imagine it becomes a law. What provision does INEC has to follow that particular law? And if it is passed into law and it is not done the way it is in the law, then
there will be a lot of issues.
Automatically.
Uncertainties.
Because they say, okay, INEC has agreed to transmit electronically, then why is it transmitted manually? Then the credibility of the process is at stake. It's in question.
Thank you very much. Now, your final words before.
I want Nigerians to actually know that we have the Electoral Act 2010, in which the 2015 election was conducted. That election was adjudged to be very free, fair, and credible. So now the implication of the president not giving assent to this particular bill is that we fall back to 2010 Electoral Act. So we actually have really nothing to lose, except of course I agree that laws must be
evolved.
But then it doesn't mean as if that calendars will not be used. It will still be used. It's just that it will not be used pursuant to INEC guidelines, not pursuant to Electoral Act.
Well, thank you very much. You want to say one final word?
Yes, I believe the 2015 election was adjudged the most credible election we've ever had.
In Africa?
In Africa. Not because of anything, but because of the use of the card reader and the integrity of the then INEC chairman, Professor Giga. So I believe it is not about the process is good. Now what is left is who are the persons that will man the process. I believe those are the questions. Those are where we should put our searchlights on. And 2015 election, the votes were monitored. That was why it was very difficult to read. By who? The citizens. People are voting. Let's do the same thing. The party agents, the citizens, let's monitor our results and defend our mandates.
Thank you very much. This is where we'll call it a wrap. on the discussion segments of Morning Safari. I want to sincerely thank Dr. Abdul Fattah Sambo, constitutional law expert and senior lecturer at the Department of Public Law, University of Ilorin. Thank you very much.
Hey, thanks for having me.
And of course, I'd like to say thank you to Comrade Isa Mutalib Ayobami, social and public affairs commentator. Thank you very much for your opinions on the program. Okay, it's about time that we get entertained on Morning Safari. Don't go anywhere.